The next case to come before us is Mitchell versus Worley. And both sides will have the 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes in rebuttal. I wanted to instruct you both to stay behind the podium. Well, that's a first. Behind the podium, and keep your voices up. And also don't be moving all around, because then we are videotaping for YouTube for our official court account. And so we don't want the camera going crazy and the video to be off center. So I know this is a workers' comp, so you are not going to be
Well, the gentleman's waiting for, yeah, he's on his way up, I believe, yes.
okay, all right, thank you.
Right.
So I know we won't be referring to victims or children or anything, but we always like to announce that to make sure that all the attorneys know that we do not do that. We refer to them as minors or as victims or by initials, something of that sort. Also, please introduce yourself and who you represent. And we've read the briefs and are ready to proceed. Oh, I'm sorry. The monitor over there shows you your time.
Oh, good.
And I will try to alert you when you're getting close, but sometimes I get wrapped up in the argument as well. I'm trying to filibuster here as much as I can, but I think I've run out of things to say. Thank you.
All right, thank you. Good morning, Mark Heron on behalf of Appellant Buddy Mitchell. I would like to reserve 4 minutes.
Okay.
Should do it. If it please the court, good morning and thank you for being here to hear this case. This is not a workers' comp case. This is a personal injury case, but there's a lot of workers' comp doctrine that is overlapping the respondent superior issues here that deal with the liability or potential liability of Michaels Corporation is the appellant in this case. The tortfeasor is not.
But nonetheless, you're trying to use workers' comp law.
Yes, yes, we are, and we think it overlaps quite concisely and logically with workers' comp law in the respondent superior context in this case.
One of the things, this is the second time I've been on this
Yes.
case, and one of the things that always is paramount in my mind when I'm dealing with either workers' comp issues or personal injury, on the job site and so forth, is the statutory basis for workers' comp and the original rationale for workers' comp. And so I'm trying to figure out from a public policy perspective how you are able to just plop workers' comp case law and just rulings in regard to an employer that is part of workers' comp system that has been statutorily constructed, or created, I should say, in order to benefit both the employee and the employer. So how are we able to just take that and plop it down into personal injury context?
Well, the courts have already done that in large regards to the coming and going doctrine. The cases that we've cited in our brief do state that doctrine applies equally throughout workers' comp cases, throughout respondent superior cases, and I believe even uninsured motorist cases, which I've never touched one of those in my life. But and even though the workers' comp system is created by statute, it does invoke into the statutes a lot of common law concepts that are akin to the respondent superior context, including being within the course and scope of one's employment in order to be eligible. That has traditionally been defined as something that is bringing a benefit to the boss. In service of the master, I think that's pretty close to the literal translation of the Latin respondent superior, as I think about it. But that concept of serving the master works across the board when it comes to the coming and going doctrine. And the issue here is whether the exceptions, particularly the traveling employee exception, ought to be entitled to the same treatment. And there's several reasons why. One is consistency. Both doctrines look ultimately at whether there is a benefit to the employer, to the master, by the servant or agent employee's presence wherever he or she is at. And in the workers' comp context, in the cases we've cited, all involve employees who were sent by their employers on long-term, multi-week, the case that came out of California, that was the Duncan case, was a 3-week job out in California for a welder at an assembly, something like that. That's what the decision said, it was an assembly site. But 3 weeks, and he slipped and fell, getting from his car back to his motel or hotel, where he was getting a bite to eat, and the court still said that's course and scope of employment. The Pasquarelli case, which is the case involving the pilot, said that where the traveling employee exception applies, the employee is considered acting for the servant or within a course and scope of his employment the entire time of the trip, unless there's a clear departure. That employee was sitting in his hotel room, the pilot was sitting in his hotel room between flights when he got an electrical shock, and that was still considered course and scope. Because of the benefit to the employer from the employee's presence, in the Duncan case in California, and the Mazdin case up in Michigan at a construction site, and the Pasquarelli case between flights, I think it was down in Florida. And that is a marked difference from the social host doctrine that Michaels is relying upon, and the cases that were that the trial court cited. There is a significant difference between something that happens at a party and something that happens when you're, in this case, about 700, 800 miles from home. Yes, in a social host case, such as those cited by the trial court and relied upon by Michaels, yeah, there's a benefit to the employer with camaraderie and what have you. All that's good, okay? Maybe that works in the workers' compensation context. But there's an added, but in the social host context, there's no benefit to the employer's clientele or customers simply because of a party. And that's what differentiates the social host cases relied upon by the trial court and the traveling employee cases that we believe ought to be applied in the responding superior context as well.
Counsel,
Yeah.
I don't recall right now, so refresh my recollection. Did Worley actually apply for workers' comp?
I don't know.
That was not discussed in any of the briefs, or?
That hasn't come up at all in the case. He resided in Missouri. If he would have been eligible for workers' compensation, that might have been something that Mr. Worley would have had to do through the Missouri workers' compensation system. I have no idea how that would work. But no, he did not apply for workers' comp, and I don't think he was even injured.
Well, I guess you just told me two things, so maybe I'm confused. I thought the record was not clear or was incomplete in regard to whether he applied or not. And then you just said, no, he did not apply.
As far as I know, he did not. I know that he was not injured in the accident, but whether he applied for workers' comp in Missouri, I do not know the answer to that one way or the other. And that would be a Missouri issue for as far as his entitlement would be concerned. But if I'm correctly anticipating part of where you're going on that question, let's take the situation and say the employer is based down in Cincinnati and sends the employee up to Youngstown, or even up here, on a long-term assignment that's going to be, a distance that's going to be far too much to drive back and forth every day. If that had been the case here and the person in Worley's position had been injured, he would have been entitled to workers' compensation benefits because he was acting in the course and scope of his employment, consistent with the Duncan case, the Mazdin case, the Pasquarelli case, and the one or two other cases that we've cited, even if he wasn't actually on the job at the time, because that was the factual scenario in all of those cases. We do think from a public policy perspective that is inequitable to allow him to participate and be determined to be within the course and scope of employment, but not be within the course and scope of employment when it comes to the employer's responsibility, liability for the injuries caused to the innocent victim, Mr. Mitchell in this case. And I see nothing in the case law, I've seen nothing in the briefing, I've seen nothing in the previous opinions. I think we're up to 3 now, at least in this case, 2 from the trial court, 1 from this court, that identifies any reason why there should be a different interpretation of course and scope for an employee who is negligent and for the victim. And I would just submit that there is none. There is no reason, no basis for having a different definition of that content, of that term, course and scope. Either you're serving the master, bringing a benefit to your employer, or you're not. And it really shouldn't matter if it's a workers' compensation context, respondent spirit context, uninsured motorist context. The definition should be the same. It promotes consistency, it promotes fairness. And that is the primary reason we're requesting that this court recognize that the traveling employee exception applies in responding superior context in the same manner that it applies in the workers' compensation context. The definitions really ought to be the same. Unless the court has any further questions, I think I've covered the points I wanted to make.
I think that's fine, thank you.
Okay, thank you.
Good morning, Your Honors, and may it please the Court. I'd like to once again thank you all for your patience in my brief delay. My name is Brianna Perslipsky, and I'm here on behalf of Defendant Mitchell's Corporation. And I think where I'd like to start is to emphasize that really there's 2 issues before the Court today. One is, what counsel just discussed as far as the applicability as a matter of law regarding the traveling employee exemption. But there's also this discussion as to whether it's even applicable to the facts that we have here. Now, the trial court, in reviewing it, found that there was no issue of material fact as to whether the doctrine could apply, in addition to finding that the traveling employee exemption did not apply as a matter of law to matters of respondeat superior. And I think one of the cases mentioned by counsel, the Duncan case, is a good example of that, because that case recognizes that even where you do have an employee who moves from one location to another, which I'll return to that point in a second, an employee can establish a fixed situs, which would be the contra of the traveling employee status, in a matter of days, weeks, or months. So in this case, we have an individual, Worley, who contracted with my client to work on a single project for what amounted to be about a year. During that time, he worked in one location. His work was confined to that location, and for matters of the coming and going doctrine, his workday did not start until he arrived at that work site. During that time, he returned home twice, once I believe for a funeral, and a second time for a holiday. Otherwise, he remained within Ohio for the entirety of the project.
But he never intended to change his residency or location. He always knew, and the employer knew, this was a temporary assignment.
Right, so, yeah, 2 things. I mean, he comes onto these projects, individually. So it's not, I would contrast it with a truck driver or a traveling salesman where, you have maybe deliver this package to Toledo. You go to Toledo, you come back, okay, now go to Pittsburgh. In this case, he signed on for a single project. When that project was over, his employment concluded. Now, he signed on for projects in the past, but he did not have continuous employment with my client. There were periods where he left and worked for another employer, and then in the future came back for another job with my client, but it's not a case of, them directing him around. It's, if they have a job, he can apply to it, he can be accepted, but it's not a matter of continuous ongoing employment. And that's really, one of the things that I think is a prerequisite to the traveling employee exception, because it's not simply a matter of traveling, but it's work where traveling is a significant facet of the work. So again, a truck driver, a traveling salesman, these are individuals who the work that they perform involves travel on a daily basis. In this case, Mr. Worley came to Ohio where he remained for the duration of the project, but his daily work did not involve travel. You know, he was responsible for getting himself to Ohio. My client did not control, you know, the means by which he came to Ohio. It didn't direct how he came and left from the work site. And, you know, in other cases, they found that, you know, if an employee is bringing other employees to the work site, if he's transporting things, that's not necessarily the traveling employee exception, but, you know, you could potentially read other obligations into there, but none of those circumstances are present here. Once Mr. Worley came to Ohio, he was the same as any other employee of my client. He had a, you know, not quite a home, but he had a room where he was staying, where he returned each day. I believe at one point he had bought a trailer where he was staying. In the morning, he went to the work site, put in his hours, and at the end of the day, he left. So this, and it's, you know, again, the same work site every day. So this is really distinct from, you know, these traveling employees, pilots, truck drivers. And the reason I wanted to highlight the Duncan decision is because we had an individual, not we, but the court had an individual in that case who went on short-term assignments for a couple weeks at a time, and in that case, while there was a finding that he was within the course and scope of his employment, it was not under the traveling employee exception. They found that he was a fixed situs employee because he traveled to these locations where he would remain for, I believe in this case, it was several weeks before moving on to another. So again, you know, between him and a truck driver, this is an individual who goes to a place, establishes a place of work where he returns each and every day throughout the course of that project. And then this court's prior decision, you know, it had the chance to review several other of those doctrines. There was the special benefits analysis and the special hazard analysis, both of which this court found were inapplicable here. So, you know, as far as we're talking about the benefits framework, I don't think that's applicable. I think the sole question here is whether or not Mr. Worley was a traveling employee, and I think the trial court, when reviewing that, properly found that he was not a traveling employee because his day-to-day work did not involve travel. He, you know, worked, he was a pipeline worker, he went there, you know, he did his labor there, but his morning commute was not part of his work. That was just how he got to his job site.
Counsel, I have a question in breaking down the trial court's entry, because it appears there are two conclusions here.
Mm-hmm.
One is, the trial court did not apply the traveling employee exception to this case. No, we're not. And also found that he was not a traveling employee. Those are, in my mind, two different, based on the other language in the entry, two different conclusions.
Yes,
Okay.
I would agree with that, yeah. And I think, you know, I don't think this court needs to necessarily decide today whether in any specific case the traveling employee exception could apply. Certainly, in our brief, you know, we argue that it shouldn't. You know, part of what Judge Carr argued in that the workers' comp framework is set up differently than matters of tort, and because a number of these other exceptions, the social host rule, have been rejected as well. But, you know, even if conceivably there is another case where it could apply, so, you know, a pilot, a truck driver, you know, I think we just don't meet the threshold of fact to even get into whether or not the legal matter.
Except for in this case, we also have the conclusion that he's under the coming and going rule,
Sure.
which is workers' comp being applied to respondeat superior, right?
Of course.
So how do you, on one hand, say I'm going to say that he's under the coming and going rule, and say that the traveling employee exception as a matter of law, not as like what his particular instances were. That doesn't apply, but this applies.
Well, I think one, we do maintain that that's a matter of fact, the exception doesn't apply. And two, I think, these doctrines do need to be taken on a case-by-case basis. I think the important thing to recall is respondeat superior isn't just a matter of benefit, it's benefit and control. So in a case like this, my client has no control over how its employees are going to and from the job site. And I think in a case of a traveling employee, I think it would come down to a matter of, what control does the employer exercise over the employee to establish that respondeat superior relationship. And again, I think that's why the cases on the social host rule are important, because it does carve out that while we're looking under the coming and going rule, it's not a one-to-one analysis. When you're looking at workers' comp, you're construing it in a way that's favorable to the employee, simply because, under 412395, that's how, statutorily the General Assembly has already made the determination that these cases should be applied as a matter of law more favorably towards the workers' comp claimant. But in matters of tort, we're looking at a preponderance of evidence. It's a more even field between employer and employee in terms of establishing that relationship. And so, yeah, I think that is an important thing to note, because even though the trial court did make that determination, it went on to look through the facts of the case, and then finding that there was no issue of material fact, that prior analysis isn't necessary or required, because, even if there are cases where the traveling employee exception could apply, as a matter of fact, we just don't have those facts here, simply because that was not the nature of Mr. Worley's work.
Plus, in my reading of the entry in the conclusions of law section, there is no analysis with respect to the respondeat superior. There's only, in the conclusions, there's only analysis with respect to traveling employee coming and going. And
Right.
whether he was under an exception, right? Is that the way you read it?
Right, that was the posture of the case, which I think in this case was a little unique, because there was a prior appeal which had addressed other exceptions and found that those weren't applicable. So in revisiting its prior decision, the trial court was looking at the very narrow question of the traveling employee doctrine. So I think that explains why it's why the opinion was specific in the way that it was. I think the only other thing that I'd like to emphasize is, in a lot of these traveling employee cases, the significant aspect of them is the frequency of the trial and, of the travel and its involvement with day-to-day labor. And not to belabor the point too much, but when you have a truck driver, a pilot, all of these, these are the cases in which the doctrine has been applied. These are not people who are making one trip and staying there permanently. These are people who, on a day-to-day basis, are traveling from their place of work. They don't have, they don't have an office. They don't have a work site. Travel is their employment. It's an essential part of what they do and what they're paid to do. So for these and all the following reasons, I'd respectfully ask that this court affirm the trial court's judgment. One, because we contend that the traveling employee exception doesn't apply as a matter of law, but two, because plaintiff here has not met the basic factual threshold of showing that the exception will apply.
Thank you. And you will have 5 minutes remaining.
Thank you. Judge Carr, I think in your opening questions of counsel for the appellee, you hit on one of the very important points, and that was the very factual issue as to whether or not Mr. Worley could be considered to have established domicile in Ohio such that he became a fixed situs employee. And there's, at a minimum, a factual issue as to that, because there's no evidence that he bought a home here, or was paying taxes here, or registered to vote here, didn't bring his family here, didn't enroll his kids in school, or anything that, people would traditionally associate with, setting up residence somewhere. That leads to a factual issue that I think a jury has to resolve as to whether or not, he became a fixed situs employee located in Ohio.
Were there any disputes as to any facts?
Not as to those facts. Those were all basically admitted by Mr. Worley at his deposition,
So,
and to a lesser degree by Michael's corporation, called it Mitchell's Corporation. I don't know if you're thinking ahead a little bit here or not, but those facts were essentially undisputed. And when
so
Mr.
that isn't a legal question versus a jury question?
I think it's a jury question as to whether or not, to the extent that they're claiming that he became a fixed situs employee in Ohio, that's a factual question as to whether the definition of what a fixed situs employee is may be a question of law, but whether he became one under the facts of this case, that's at a minimum a factual issue for a jury to decide. I think the facts are pretty clear on Mr. Mitchell's side on that, but at a minimum, a jury should decide that. And that leads to the second point, is that there's no, at least in the case law that, in Ohio, on the traveling employee section, or exception, there's no fixed determined factor as to how much time has to pass before it becomes, a temporary assignment, or it becomes, well, for all intents and purposes, you're living here even though it's a temporary assignment. In the Duncan case, it was 3 weeks, 3-week assignment for an Ohio employee out in California, who was not traveling on day-to-day. He was a welder at an installation or assembly project. The Marsden case, which, there was no, actually there's nothing in the decision that indicates that how long those 4 employees were up in Michigan working at he was the carpenter. There's nothing in the decision indicating how long that assignment was. But I haven't seen any hard and fast legal rule as to how much time must pass before it changes from a traveling employee to a fixed situs, even when it's temporary. The council also was, I think, factually erroneous with regards to Mr. Worley's work history at Michael's. I almost called him Mitchell's. He had worked in several other states. When he gave his deposition which was after the Seville, Ohio project ended, he was working for them in Minnesota. And I don't think there's anything in the record indicating he was working for other companies in between. But either way, he was sent by Michael's Corporation to Ohio to work on that pipeline project in Seville, and they had to stay here for as long as it took, which sounds about like the situation in the Duncan case and the Madison case. They were going to be there for as long as it took.
Yeah, just about a minute.
Yeah, the council also brought up the issue of control in addition to the issue of benefit to the employer, control by the employer. In the Duncan case, which is the welder case, the employer didn't have any control over where Duncan went to eat, or what time he went to eat. When he slipped and fell and injured himself, and was still determined with the course and scope of employment. In the Madison case, which involved a fight that broke out at the hotel, the employer didn't have any control over whether or not they woke up to get rid of what was going on outside their door that was keeping them awake. But there still had to be in the course and scope of employment. And this case really is no different. From a factual standpoint, it really is no different. As I noted earlier, I think there's an inequity in holding that the coming and going rule is going to apply across these various contexts of workers' comp and respondent superior, but to say that the traveling employee, when all the other facts are the same, was that traveling employee exception is not going to apply. That is not equity. That puts people like Mr. Mitchell at harm. And for these reasons, and for those previously expressed in our brief, we would ask that this court find that the traveling employee exception applies as a matter of law, and remand the case to the trial court for the factual issues to be decided by a jury. Thank you all very much.
Thank you. Thank you both for your presentations. And the court will take the matter under advisement and will issue a written opinion that will be sent to both sides, and then we also release electronically on the Ohio Supreme Court site.